On this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thank you.
All right, let us get right to it. We've got several topics to discuss, and one concerns the Missouri River and a recent case that the U.S. Court of Appeals for the Federal Circuit made a decision on, and the Court of Appeals said that must pay for, or it's Corps of Engineers, I'm sorry, the court says the Corps of Engineers must pay for mismanagement of water levels in the Missouri River.
Yeah, they're going to have to pay big time. This case in litigation has been going on for about a decade, and actually the flooding at issue was for most of the years between 2007 and 2014. And listeners will probably remember, if you ever traveled that I-29 corridor, basically from Kansas City, or more specifically, from about the corner of, now they don't exactly touch, but Kansas, Missouri, Nebraska, Iowa, right in that corner up in there, all the way up to Fargo. There were some years where I-29 was completely underwater. You couldn't get through. It was torn up for quite some time. And that happened several years in a row. In fact, one year was pretty bad. I think it was 2011. There was sufficient, quite a bit of rain out in Montana, a lot of snow melt. And that year, the Corps of Engineers released excess water from Gavin's Point Dam up in South Dakota and created an absolute mess. Well, the question was, did the Corps of Engineers conduct actually create the problem or make the problem worse? Or was that going to happen anyway as a result of the flooding? Well, we've had several court opinions on this, and most recently we've had the U.S. Circuit Court of Appeals for the Federal Circuit in D.C. Deal with an opinion out of the Federal Claims Court. The Federal Claims Court, by the way, is where you take a takings claim. So if you have a claim against the government that the government has acted unconstitutionally to take your property in violation of the Fifth Amendment, and you should be awarded compensation, your avenue is to go to the U.S. Court of Federal Claims. There's a specific act that says that's where you go. Now, the appellate court that reviews that is the D.C. Circuit. And we got the D.C. Circuit opinion most recently, but back in the Federal Claims Court, the court said yes, and this was an opinion back in late 2020, so December 14 of 2020, the Claims Court, the U.S. Court of Federal Claims, said that, yeah, these farmers along the Missouri corridor, and there were about 400 farmers involved, but there was a class of 44. Some of them were entitled to compensation, but the Claims Court had thrown out, in terms of a compensation award, damages for the 2011 year, and they said we're not going to value crop losses, so just property damage, but not crops. So that's where the case stood, and it went on appeal, and we just got the appellate opinion about 10 days ago.
Yeah, you go back to the early 2010s. It was unbelievable. I remember quite clearly the pictures that were coming out of there, specifically looking at the corridor I-29 there along the Nebraska-Iowa border, and then subsequently all the issues the state of Missouri had on levee dam breaks and everything else that they had.
Mm-hmm. Yeah, I can't imagine being a farmer along that corridor. I recall getting through there when I-29 was open. I speak in North Dakota frequently, and so I go back and forth between Fargo, Grand Forks, and, of course, Kansas City area up through that corridor. And it was just breathtaking as you went through there. It's like, oh, my goodness, these poor people are just devastated by what happened, and the levee breaks and the property damage, let alone the crop loss and the destruction to the land itself that will recover, but it's going to take some time for that to recover. And just putting a dollar value on that would be absolutely incredible. But in that early litigation, the court said that 28 of the 44 bellwether plaintiffs had proven their elements of a takings claim. The other 16 couldn't prove causation, and so that has to do with the physicality and the geography of the land involved, the location of it, and the water flow and so forth. They just couldn't prove causation of their damages by the Corps of Engineers' conduct. So then you had further litigation on this, and there were actually some Kansas plaintiffs in this, clear up in that northeast corner. And the court said that 3 of the representative plaintiffs, farmers in Missouri, Iowa, and Kansas, were collectively owed more than $10 million for the devaluation of their land due to the establishment of what they said the Corps received by its conduct was a flowage easement. They had taken a flowage easement, the right to flow that water over their property, from those landowners. And the Constitution says, of course, the big bad federal government can take your property if they want to, but the Constitution says when they do, they have to pay you for it. And so the court said, all right, government, you took an easement to flow water over these farmers' property. You now have to pay for that. The Fifth Amendment requires that you do that. But again, as I said, that point in the damage phase of the case, the court said that they didn't have to pay for crop losses. Well, that's a big number if you factor in crop losses on top of that. But the impact of the court's ruling a couple of years ago was that the Corps was going to have to pay a lot of money. We just didn't know how much, or whether 2011 damages would be included in that and crop damages would be included in that. And now we've had the appellate court rule on those 2 issues.
Does it go down to that, as you mentioned earlier, certainly the government can take land, but obviously there has to be the proper compensation if they're going to do that too?
Yeah, we can't stop the government from taking land. I mean, we can try, we can challenge their conduct in court, but that's likely not going to be the case that you're going to prevail. What you need to focus on in many of those instances is that, I should be paid for this. You can take my property, but you need to pay for it under the Constitution. And then the battle is how much the government has to pay. I recall many years ago, people will remember that the highway from the interstate into Manhattan only used to be 2 lanes. Well, you didn't need 4 lanes when K-State football wasn't any good. Well, that changed, and now you had a lot of traffic coming in there. And I remember the rancher that owned a lot of that land at the time coming in to see me in my office at K-State at that time. And I told him that I said, well, the state's going to be able to do that, and the government's going to be able to take that property from you. But you need to focus on what you want out of this, what you want to get paid, and maybe throw something else in there on that. And of course, it turned out they were able to take some of his ranch. They did, and it's a 4-lane highway. But if you'll notice, as you drive into Manhattan, there's a side road, and that side road is named after him. It's in his last name, and that's something he was able to get through his attorneys in the negotiation process. And that's what you have to do in these types of situations. Now, the nice thing for these farmers about the appellate decision that just came down by the Federal Circuit was that the court said that the trial court made a mistake in ignoring 2011 in the damage calculation, and the court said, we're going to vacate the lower court opinion not only on that, but on the fact that they didn't factor in crop loss damages. So, and that's to both mature crops and immature crops. And so the compensable taking is for a flowage easement and crop damage, and the lower court had failed to consider that. So the appellate court said, we agree with you that there was a taking that these farmers have to be compensated for, but you didn't go far enough. You're going to have to add those things into the calculation. And this is all stemmed from the Corps of Engineers changing its manual for how it determined when and in what quantity to release water into the Missouri River. And the court said that, you can do those things, but you cause damage, you're going to have to pay for it. So big win for farmers along the Missouri River corridor.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is our guest on the program this morning. Roger, let's stay in the courts as far as decisions are concerned. This goes down into Louisiana. What is the But this is a situation I'm sure many have run into where the state, be it in this case Louisiana, fixing a bridge obstruction too late to save a farmer's wheat crop.
Yeah, and you mentioned this is in Louisiana. I just came back from speaking in South Georgia, and it's really stuck out at me how much water is down there in North Florida and South Georgia. There's water everywhere. The ditches are full of water. There's swamps all over the place. And I think our farmers in Kansas would just die to have some of that water. And so it's important that this is a Louisiana case because of what we're going to talk about here. You had a farm that had a wheat field adjacent to a state highway, and there was some rainfall and sufficient rainfall that it needed to drain into a road ditch, and that was the normal drainage of this property. The property would normally drain into a road ditch, and there was a bridge at the road, and the county had failed to keep that ditch clean, and it had built up with silt and debris over time, and the water couldn't flow, and so it was backing up into his field and flooding his wheat. And so he talks to the it was a state highway. He talks to the State Department of Transportation and Development is what it's called in Louisiana. And they said, well, we've got other projects that we're on right now. We'll get to it. And he goes back and talks to them again several days in a row. Says, this is important. I'm going to lose my wheat crop if it stays underwater. This obstruction needs to be cleared. Well, 2 weeks after he first contacted them, they finally clear the obstruction under the bridge at the road. But with his wheat crop being underwater for 2 weeks, he lost his entire wheat crop. So he sued, and the court basically said, well, the state's got a wide degree of latitude in making decisions as to where they devote their resources to certain projects, and 2 weeks we think was a reasonable time. So he lost his entire wheat crop out of that field in that situation.
And that's not uncommon that the courts, or in this case, would give the government agency the reasonable discretion, I guess, for performing their duties?
Yeah, that's right. The state is given pretty wide latitude in these types of situations, and if they have limited resources, which they do, and they have prioritized their projects appropriately, the court's not going to step in and change that. Now, I'll tell you what most farmers would do in this situation, and I don't know by reading the opinion what the specifics of his situation was, but I think most farmers, particularly in Kansas, I know what I would do. I'm getting my equipment out of the barn, we're going down, and if we can clear that ditch without causing any type of traffic issue, if I can do it without even being on the road, I'm clearing the ditch. And then we worry about the consequences, if any, later. But it just depends on the situation. He may have had a situation where he couldn't get any equipment down there without putting it on the road. That you cannot do. You can't create any type of traffic hazard. But if you can do it operating from your property, yeah, clear that ditch and then have the county get enough of it cleared to get that water out of there and have the county finish the job later on. But hopefully he had crop insurance to cover that loss. But the point of the case is the state, the county, the government's going to have wide discretion given to it by the court to prioritize its projects. And as long as it's reasonable and they can establish that, then you really don't have any recourse against them.
Roger, one final, in this case, opinion that we're going to talk about. This came out of the 8th Circuit Court, I believe in Missouri, and for many, this is a situation they run into as well, or at least working with buy-sell agreements, and this involved a buy-sell agreement for a corporation owned by two brothers.
Yeah, that's right. One brother had about a 78% interest in the small corporation. And it's generally common for closely held business owners to enter into buy-sell agreements, which will establish the terms for the acquisition of a deceased owner's interest at death. And we use those in farming and ranching commonly to keep the stock interests in the farming or ranching corporation inside the family. That's very important to certain farming and ranching operations, so that it's not held by somebody outside the family. And so not only is it common to see these buy-sell agreements, it's highly advisable. And in these arrangements, it's also common to fund the purchase with life insurance. So if I'm going to buy out my sibling that buyout agreement is not, that buy-sell agreement is not operational unless I have funds to exercise my right to buy my sibling out. And often we use life insurance to do that. And the point of this case is you have to strictly adhere to the terms of the buy-sell agreement if you're also trying to use the buy-sell agreement to get a valuation discount for estate tax purposes. And and this is going to become more important if Congress doesn't deal with what's going to happen after 2025. The current exemption for federal estate tax is $12.92 million. Not a big deal for a lot of people because that's pretty high. But if Congress does nothing, that's going to come down to $5 million, adjusted for inflation in 2011 dollars, is probably about $7 million or so. At a time in 2025 with two more adjustments, it'll probably be close to $14.5 to $15 million. So if that exemption comes down, then we get back into these valuation discounting techniques. Well, there's several ways to set up buy-sell agreements. And what happened in this instance is that they used a redemption purchase type arrangement. And instead of a different way to structure that. So what happened in this instance, to cut to the chase, was they didn't follow the terms of the buy-sell agreement. It didn't result in the valuation discount. The proceeds of the life insurance were deemed to be part of the value of the corporation, which then became subject to federal estate tax to a tune of an additional excess over $1 million of tax. So instead of transitioning the business to the next generation in a tax-favored form, because they used the wrong type of a buy-sell agreement with the wrong language in it and then didn't adhere to its terms in terms of the way they valued the business, they ended up creating an additional tax of over $1 million. And so we just don't want to see that. We want the death benefits not to use to fund the plan inside the corporation. We want that to go to the other individual that directly so that they can buy it out. And that's the lesson of this case.
Yeah, using it as a funding vehicle and not as a corporate asset.
Yeah, we want to make sure that, well, the terminology is whether it's a cross-purchase agreement or not, but we don't want the corporation to actually have the proceeds go to the corporation. Have it go to the other individual that is the one that's going to buy it out. That's the lesson of this case. Now, I would say that this case is contrary to the lead case on this issue. So we've kind of got a split of authority now between a couple of court cases, but this is the Eighth Circuit Court of Appeals. So this one's binding in a lot of farm countries. So it's Arkansas, Missouri, Iowa, Minnesota, and the Dakotas, as well as Nebraska, is where this court opinion will apply. It's a big deal. It's a very technical one. I'm going to put a blog article out on it later this week, but it's an important case for proper structuring of buy-sell agreements and then carefully adhering to them so that you don't cause an additional tax problem. And I would say, again, just to reiterate, not that big of a deal right now, but if Congress doesn't deal with this federal estate tax exemption issue, that exemption is going to be cut basically in half from where it is now, starting in 2026.
All right, Roger, if people want more information, or as you mentioned, you're going to put several things up on the blog, what's the best way they can find it?
Yeah, the first case we talked about is up on the blog, the Corps of Engineers case along the Missouri River. That posted yesterday, and I'll get the other cases up there this week. That can be found off my website, which is washburnlaw.edu/WALTR.
All right, sounds good. Roger, as always, very much appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.